This is Dr. David Schein, and welcome to Business Law 101. I wanted to again mention, I mentioned this term earlier in the course, tender of performance. That means that you have offered to perform, and that is sufficient under the law of contracts. An example I use is, and tonight's a very good example of that with the heavy rain. The cleaning service for your office building shows up and says, we are ready to perform, to come in and clean all the offices and empty trash cans. The person who's managing the building meets the cleaning crew at the door and says, wait, stop. Nobody came into the building today. The building never opened due to the storm conditions and so forth. Everybody go home. Well, the cleaning crew is already at the building prepared to perform. They are tendering performance. And under those circumstances, whether they clean the building or not, in most cases, they're entitled to be paid, or at least entitled to be paid some show-up pay, because the manager should have called them earlier to say, do not come tonight. And even then, they might still have incurred a responsibility. Now, one of the issues that we get into is substantial performance. My favorite example of this, and it's actually outside my window here from my Heights office, is my next door neighbor had a detached garage built behind their house. I can actually see it out from behind my computer screen here. And when the building was substantially complete, there were two wires sticking out, one on each side of the big garage door, the big power door, and there was no lanterns there. Obviously, it was designed to have a pair of matching lanterns put on the front. Now, the question came up is, this was a $25,000 project. Would the owners of the house be entitled to hold all $25,000 if all it was missing were the two lanterns? And the answer is no. The contractor had met substantial performance. My best guess is the two lanterns, exterior lights, were on order, and they should have been paid. Now, if I was the homeowner, I might have negotiated the following. Here's $24,500. When my lanterns are installed, I'll give you the other $500. But let's keep in mind what's in the contract. Express conditions, again, is what we want. But sometimes you miss. Constructive conditions must be significantly performed to avoid a breach, but are not as strong as express conditions. And keep in mind, substantial performance is not a complete performance, but it may be an immaterial breach. Now, note another special issue in contracts here as we approach the end of this module is installment contracts. So keep in mind that there's continuing obligations on the parts of each party. And the example that I used earlier of the organic whole wheat flour being delivered every Tuesday, that's an installment contract. It hits when the wheat is delivered, obligation to pay, obligation to deliver the wheat, obligation on the other side to pay, and so forth. That's the type of situation we're looking at in installment contracts. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.